Hello, my name's Dan Dodds. I'm the principal attorney at the Dodds Law Firm in Surprise, Arizona. Today I want to talk to you just ever so briefly about this really big concept called community property. And it's foreign to most people that weren't born and raised in Arizona because the vast majority of the states are single property states. And I'll explain that difference in a few moments. Think about community property being everything that we acquire as a couple, debt and asset, from the day we married to the day we're divorced, is considered community property, regardless of how the title on that property might say. So, for instance, if my wife and I have one of those marital moments and she makes me angry, so I go, okay, well, after 55 years, I'm not going to let you treat me that way. So I'm going down and I'm going to buy myself a new pickup, unbeknownst to her. So I walk onto the lot and I say, what's the fanciest, nicest four-wheel drive pickup you got on this lot? And they go, oh, you're going to love this one. It's beautiful. Got everything on it, every train, whistle blower, everything. How much? $97,000. But it's a deal. Okay, I'll take it. I only title it in my name, and I only sign the loan document in my name. And I bring it home. I drive it up in the driveway. I walk in. I throw the keys on the kitchen table and say, look what I just bought. And she looks out the window and here's this new $97,000 truck sitting there. And I look at her and I go, well, you got a problem. Why? Because half the debt's yours. And it is, because we purchased it for the benefit of the marital community, to get me to work, to take me to the doctors, to go pick up groceries at Walmart. So the reality is, whether my name's on it or not, it was purchased during the marriage, and the marital community property money was making the payments on it and the insurance payments. So that's a part of the story you need to understand. Now, there is an exception. What if my wife inherits, let's say, $50,000 from her parents when they pass, and she gets that $50,000? Well, she got it through a gift or through inheritance, so it's still hers. Now, she could lose that single property protection if she puts it in a joint banking account or puts my name on the title of the $50,000, let's say in this example, boat. Now I own half the boat. So you really want to be careful when you inherit something or if someone gives you something. If you don't want it to be considered to be community property, you need to be careful how you treat it and how you identify it. And I think you should, if it's worth a lot of money, you should speak with an attorney to make sure you understand all the implications of community property debts and liabilities during a marriage in a community property state in comparison to perhaps like Oregon, where it's a separate property state. And it doesn't make any difference whether I put the money, as long as we can trace it in a community property, a joint banking account, no problem. I hope this information hasn't been totally confusing to you, but it is an important concept, and I encourage you that if you're thinking about divorce, it's probably time for you to set an appointment so that you can better understand how the court may treat your property, whether it be single property, gift, inheritance, or community property. Have a good day.